Hello everyone. So this is my English law channel, and this evening I'm going to talk about legislation. So legislation means lawmaking. So various legislatures make it, but we're principally concerned with the Parliament of the United Kingdom for this. I know it's the law of England and Wales, and the laws for England and Wales are made there. I know that Northern Ireland and Scotland are represented there also. We're only looking at the ones that affect England and Wales, sometimes affect the whole of the United Kingdom, but it's really England and Wales that we're concentrating on here. So these are called statutes, pieces of legislation that are passed by a legislature. Someone who's in this place is a legislator. He or she has the right to help to pass or indeed to block legislation. So remember, the Queen in Parliament supposedly makes it, even though the Queen isn't really in Parliament. So what has to happen? Well, it has to be passed by both houses of Parliament. So they start off with draft legislation. That's a proposal, and to be debated. And so the governing party usually introduces it. There can be private members' bills, which are could be by an MP of the governing party, a backbencher, or a backbencher from one of the opposition parties. And there are a few days a year in Parliament which are set aside for debates or legislation proposed by backbench MPs of whichever party. So anyway. Occasionally, someone who's not in Parliament can suggest it, or an organisation outside, but I can't think of the last time that happened. So there are special lawyers known as parliamentary draftsmen. I suppose we could say draftwomen. So them are women who are experienced and gifted in actually writing it in the correct legalese. Because in law, a word may not bear the same semantic value as it does in ordinary conversation. And they often have to write in things like, for the avoidance of doubt, the following list is illustrative, not exhaustive, and things like that. And to lay it out properly, have articles and clauses and subclauses and so forth. Okay, so there's the Office of Parliamentary Counsel, and that they're the ones where the parliamentary draftsmen are working. So they're trying to make it lucid, and understandable, all the rest of it. Okay, so most of these are public bills, and there's a law which is going to affect everybody. There are also private bills, which have a different procedure, and they are particular to a certain organisation or certain county or something like that. Okay, so anyway, there's also the finance bill, as in that's the budget, and that's to be passed through Parliament, and that's been passed every year since like 1910. But this always begins in the Commons, the budget. The Lords have got no say in it. The Lords have got a say in everything else. And the last step is obviously the royal assent, and then the bill turns into an act. When it's enacted, it is law. So legislation is scrutinised really before the process gets going. So this is where various suggestions can be made to improve it. They can be sort of friendly amendments, if you will. It's not because people are necessarily against it. Some people say, well, I don't like this, but if we're to have this bill at all, it should be like this. And then there are green papers which are written, and this is a sort of discussion document which is circulated to interested parties, both MPs, and it's for sort of extra parliamentary discussion as well. And then people can make propositions like get rid of that article or change this one, or the whole thing's brilliant, or whatever. So there also then you have a white paper, which is a longer and more detailed proposal. There's the Rights Brought Home white paper of 1997, which turned into the Human Rights Act, for example. So then there are draft bills. So the government publishes these, and if there's going to be any more public consultation on these, a select committee or a joint committee will look at these. A joint committee meaning both the House of Commons and the House of Lords, but select committee in the House of Commons, which will only have, like, say, roughly 10 MPs. There's a chair of the select committee who isn't always from the governing party, can be from a minor party. And in the select committee, the MPs on it are in rough proportion to their party strength in the House of Commons. So like there's a Foreign Affairs Select Committee, a Finance Select Committee, an Education Select Committee, a Health Select Committee, and so forth, discussing various matters. So obviously the Select Committee will examine draft bills which are pertinent to their remit, and tends to be a less adversarial approach, more constructive. Even if you might be totally against a thing, you wouldn't be raising the temperature. And Tony Blair said one thing about the House of Commons is a lot of it is just theatricality, and this is not playing to the gallery. They are calm and dispassionate in this, that they don't have the sort of hijinks and antics that you see at Prime Minister's Question Times going on there. All right. So then how else does it go through Parliament? There's a similar process to go through in both houses. So if it starts in the House of Commons, it goes through the first reading, then the second reading, then there's the committee stage, go to the select committee, there's a report stage, there's a report from the select committee, what should we do about it? Should we drop Article 3? Should we leave Article 1 and 2 as they are? Should we add a fourth article or what? Anyway, and then there'll be a third reading. And then it goes to the House of Lords for a first reading, second reading. There's a committee stage in the House of Lords. There's a report stage, as in people are dealing with the report produced by that same select committee, and finally a third reading. So consideration of amendments. Are the amendments going to be accepted or not? Okay, and then assuming it's been passed by both houses, go for royal assent. But it quite often comes out rather different from that it went in. Might have to be watered down or extra things added in, like reminds me of the Labouchere Amendment in the 1880s. This legislation, something completely unrelated, but Henry Labouchere, a Liberal MP, put in a special amendment on another piece of legislation to say that all homosexual acts had to attract a greater sentence of like at least 2 years hard labour, and he got that through. Anyway, it's unusual for bills to start in the House of Lords, but they sometimes do, in which case it would go through a first reading, a second reading, the committee stage in the House of Lords, then the report stage, then the third reading, and then, assuming they pass it, go down to the House of Commons, again, first reading, second reading, committee stage, report stage, third reading, and assuming it's passed, then the royal assent as an agreement, and then la reine le veut, it is law. But the great majority of legislation starts in the Commons. Okay, so the first reading, that's where it's presented to Parliament, and the short title is read out loud, because the long title is often very, very long, like could be 50 or 100 words. But the first reading, it really just is a reading. They don't debate it then. Okay, later on, so there's a second reading, and that's the first chance that people have to debate the core of the bill. Is it a good idea? Is it a terrible idea? Or what? And so the government minister or whoever is proposing this bill will put it forward. There might be a department that's responsible for it, like the Treasury or the Department for Trade and Industry, or whatever it is. So obviously people can come back on that and say whether they think is good or woeful about it. There's a committee stage, as I say. So public bill committees, if it's in the House of Commons, this means they used to be called standing committees. They can have up to 20 MPs on them, but it's unusual to have quite so many, in which they will discuss the particulars of the bill. Anyway, so as I say, the committees are all specialised. So almost all legislation goes to a committee like this. Money bills don't, right? Anyway, so that's gone through that stage there. Sometimes there's a committee of the whole House, but this is exceptional. So after 1945, there's a convention that bills which are thought to be really crucial to the Constitution have a committee stage in the House of Commons, as in the main debating chamber, not a select committee. So that's called a committee of the whole House. And so all the MPs can say their piece. And that is treated in the same way as things like the Succession to the Crown Act 2013, when they said male primogeniture is over. It's going to be the eldest child, regardless of sex. And also that monarchs are allowed to be married to Catholics. Being married to a Catholic would not disbar you in future. You can't actually be one. Although, curiously, nowhere in legislation does it say that the monarch has to be a Protestant, an Anglican, or any type of a Christian, so long as they're just not Catholic. I suppose because when this whole thing came in the 16th century or 17th century, well, Reformation in the 16th, but exclusion of Catholics in the 17th century, it didn't cross anybody's mind that the British royal family would be anything other than Christian, because Jews had only been admitted to the country about 40 years before, and there were virtually no Muslims. Okay, the European Union Withdrawal Act 2018, that was of the Committee of the Whole House, because it's thought to be of the first importance, and therefore every MP had to have his or her say on that, as it were, in a committee stage. So in the House of Lords, every single bill has its committee stage on the floor of the House. Okay, so every peer can chip in. So now some people says, oh, this is scrutinised more thoroughly, therefore by a broader range of people. But it slows things down, and then people who are really non-experts chip in. Whereas if you're on a select committee in the House of Commons, that means that you're especially enthusiastic or curious about this topic. Anyway, so go on to the report stage. So this involves pondering this more deeply. There's a committee stage at which various changes can be made or discuss other changes that they might not be made. And then finally, the bill goes to its third reading. So the House of Commons is the last chance people have to debate the provisions of the said bill. But amendments can't actually be made. Anyway, they can only be proposed. In the House of Lords, amendments can be made to the bill. Anyway, so, but it goes back to the Commons. Are they going to accept these amendments or not? Anyway, so after the third reading, the bill moves to the other house, and it's basically the same process. So each house thinks about the amendments the other side made. Do we accept them? Do we not? Okay. If both houses concur on the amendments, if there are any, there almost invariably there are, and the precise words of the legislation, then it goes for royal assent. The Queen signs it. La reine le veut. So bills can go back and forth, be ping-ponging back and forth between the two houses until they agree. But anyway, if the bill doesn't meet with assent, then the whole thing fails. Anyway, so the House of Commons can use the Parliament Act, of 1949 to force it through the House of Lords. I mean, it's going to be law, but there's going to be a 1 year delay. As I pointed out, the Commons seldom does that because it used up a lot of parliamentary debating time, not just the 1 year delay. That's a problem too. Anything else I would point out? So obviously sometimes bills are defeated totally. Like remember Theresa May, she resigned in July 2019 because she had thrice failed to get her Brexit bill passed. Now, how fast can legislation happen? Really fast, if needs be. There was some legislation needed for Edward VIII's abdication in December 1936, and all that went through all three readings of both the House of Commons and House of Lords in 1 day, because it was very brief, just a few sentences, and it was completely uncontroversial. But I don't think anything's been that fast. There are proposals, things that get nowhere, like Stage 2 House of Lords reform, for decades, but there's not been a bill for that as such. Okay. So, although the House of Lords were able to delay the abolition of the slave trade by over 30 years. Anyway, go back to the royal assent. So that is the Queen simply saying that she agrees with the legislation, and that is the merest formality. It's not since 1708 has a monarch thwarted the will of Parliament. So sometimes there is scrutiny which is post-legislative, and a select committee will look into a law passed some time ago and see what its application is, and might find that it's found wanting in some way. There are things called framework bills, and these are statutes, and they exist in a certain framework. They exist for a reason. They've been very complicated. So later clauses can be added to an already extant bill or act, I should say. So this is thought to be a sensible way to deal with things, faster way of dealing with things. But these don't get examined quite so carefully as primary legislation. It's really secondary legislation. Secondary legislation is like a law made on the basis of primary legislation that's already there. About how to administer a piece of legislation that is already extant. So for example, the European Union Withdrawal Act 2018. There are some things which are known as multi-topic bills, and these are sometimes known as Christmas tree ones or omnibus bills, and they are utilised by governmental departments to attach a broad range of bits of legislation, these topics, and people call it Christmas trees, and you hang lots of lights and so on a Christmas tree. And there's the Localism Act 2011, for instance. So as such, bizarre and broad legislation can be a headache, because it's very tricky to examine this properly, because it's dealing with all sorts of different disparate things which are not interconnected. So the amendments could come in on anything. Anyway, and there's always sometimes mistakes are made. Like, well, famously, this is going back, not really a Christmas tree bill, the Offence Against the Person Act, which forbade kicking, slapping, punching, using a blunt instrument, using a sharp instrument, stabbing, shoving, pulling, pushing, that kind of thing. All these crimes of violence, but it didn't forbid biting. And so one man, he bit somebody else's nose off, charged on the Offences Against the Person Act, not guilty, because it wasn't prohibited. They just slipped up and not put that in. All right. A thing called delegated legislation, or secondary legislation, or subordinate legislation, all really the same thing. But this is quite important because there are thousands of pieces of delegated legislation which are passed, and not that many acts of parliament, like 10, 20 tops. So delegated legislation means it allows others to legislate. So Parliament is giving other people the power to do so. Other bodies, sometimes government ministers, just sign things into law pursuant to a framework act. So this is like an empowering act. So, but some people think that's bad. It puts too much power in the hands of the executive, right? And so we shouldn't treat the executive as lawmakers. It should be legislators who do this kind of thing. I know it's confusing, the efficient secret of the English Constitution, that lawmakers and the executive are fused in many cases. All right, there are things called statutory instruments. They're known as SIs for short. And there'll be a legal office in each government department, and they will come up with this. So the statutory instrument is a type of delegated legislation, and there are thousands of them each year. So most of these aren't actually debated in Parliament and just become law on a certain date, signed into law. Again, a bit contentious and not widely known about. Like Labour under Tony Blair created tens of thousands of crimes, mostly through that method. So how does Parliament scrutinise delegated legislation? There's a thing, you can have an affirmative procedure or a negative procedure, and that is about statutory instruments that to be approved by both houses of Parliament so that they can become law. But anyway, well, that's the affirmative legislation. This affirmative procedure, where they're considered by both houses. The negative procedure is where the statutory instrument automatically becomes law unless either house says no. So the thing to understand in relation to statutory instruments and other pieces of delegated legislation is that they are needed. So we're told for the government to function smoothly, but some people are worried that these make ministers overmighty. And it's degrading Parliament. People call these Henry VIII clauses, as in he was a despot. So these are clauses in a bill which empower a minister to amend legislation, to get rid of legislation, and so on, using secondary legislation. And it's not scrutinised properly by Parliament. There's the Lords Delegated Powers and Regulatory Reform Committee, and it looks at this to try and see that the so-called Henry VIII clauses are not being abused, and because I think some people think it's concentrating an excessive degree of power in the hands of the executive. So, so a Henry VIII clause will allow a minister to create legislation, or indeed to change the provisions of an extant Act of Parliament, and to remove something, saying it's incompatible with something. So let's say Section 10 of the Human Rights Act 1998. So looking at Section 8 of the European Withdrawal Act 2018, it gave the executive the right to wield very broad-ranging powers, almost unfettered powers. So the executive could create regulations in order to deal with any shortcomings in the retained EU law that followed. Because remember, the default setting is all European law extant in the United Kingdom remains on the statute book unless specifically repealed. So they want to throw the baby out with the bathwater. Some of it's non-contentious, some will work perfectly well for decades, and then we wouldn't know what to put in room of it. So people say that's wrong because you give them such wide-ranging discretion, him or her, and they could really abuse it. So they shouldn't be able to just do these things at the stroke of a pen. It's giving them near dictatorial powers. Okay, so that is a bit about the legislative process. So next time when we come back, we'll look a bit more at the judiciary.